There's something of a contentious history about allowing people aid in dying. Perhaps you could put it into context.
Well, I can speak from my experience of the last 25 years. And I would say in the early 90s, partly related to the AIDS epidemic and the fact that a lot of people were dying shockingly young and dying really difficult deaths, and who came from a community that was used to activism and social change, that the impetus for changing how we empower dying patients with choice really moved into the public eye. And there was a lot of desire for more choice to be available to dying patients, so they didn't have to bear the final ravages of really difficult deaths. And so in the early 90s, there were two cases that were brought that I was involved with, one on the West Coast, one on the East Coast, in the federal courts, that were designed to move through the courts with the end result that the choice of a dying patient for a peaceful death would be recognized as a matter protected by the United States Constitution. That didn't happen in those cases. What the court invited was for the states to grapple with the issue in the first instance, which sent us back to venues like Oregon, where the Death with Dignity Act was adopted in 1994 by statute that the voters embraced. And then gradually, after some significant period of time with experience with the Oregon law and the opportunity for all stakeholders to watch what was happening in Oregon, confidence began to grow that the availability of aid in dying not only didn't impair good end-of-life care, but it actually raised the floor for good end-of-life care for all patients. And doctors got busy learning how to treat pain and symptoms, more strong pain medications were prescribed, more hospice referrals, earlier referrals, and all of that raised the floor for good end-of-life care. With that data, other states started to feel more confident, and so we started to see what I think is an emerging trend of broader support, and now Washington followed, and then Montana with a court case similar to the ones I mentioned, but a state court case, and Vermont, and now most recently California. So there has been a growing move toward empowering patients with more choice.
What's the model for this kind of law?
Oregon enacted its statute through voter initiative after two failed attempts, Washington State and California. So when Oregon took its ballot measure forward, it was in the wake of two defeats. And the Oregon statute was crafted to address all concerns that were raised. And so it was a pile on the kitchen sink regulatory scheme. And it's a very elaborate, complex, burdensome scheme. That model was adopted in Washington. It's been essentially adopted in Vermont, and it's been now adopted in California, but even more restrictive. California's enactment is the most restrictive in the nation. So my own view is that that's going in the wrong direction, because what we know now from some 20 years experience is that this act, the option of aid in dying, doesn't put patients at risk. And the important thing is to start to move aid in dying into a normalized practice of medicine. And medicine is not governed by statute. It is governed by best practices. So my own advocacy is focused on moving this choice into a more normalized practice of medicine.
How do hospitals and hospices see their liability when it comes to implementing the law?
I think one of the things that the provider community is grateful for when these statutes are enacted is there's clarity about immunity for the provider community from civil, criminal, or disciplinary exposure. And that's important because doctors are very cautious by nature and training, and they will not engage in provision of medical care where they feel that they're at risk. So one of the nice aspects of these statutes is they create a safe harbor for clinicians. And clinicians have clarity that if they comport with the law, that they will be protected from all of those forms of exposure. And that increases the likelihood that a doctor will be willing to provide aid in dying. What we know from the data nationally is that hospital death of a patient using aid in dying is extremely rare. Most patients want to die at home, and when they are in the final stage of their dying process, they may be receiving hospice care at home, and they are typically, if they act, to ingest the medication at home. So it very rarely comes up in hospital.
Describe, if you would, the restrictions that you would like to see lifted.
The California statute imposes a 15-day waiting period. That can be very long if suddenly you find yourself in extremis where it's important to get relief from suffering and you're ready to die. Going through multiple requests, oral and written, and a mandatory minimum 15-day waiting period is too long for some patients. And we know we don't permit that kind of burden on personal choice, for example, in the reproductive rights context. We allow brief waiting periods imposed by states sometimes, but we don't allow a 15-day waiting period. So that's an example of an overly burdensome restriction.
Some people feel that the law will enable undue pressure to be put on people to accept aid in dying.
There have been concerns raised about whether patients might be coerced to choose aid in dying, and that's been the subject of careful examination over the 20 years that aid in dying has been openly available, and there has been no evidence of coercion. So I think one of the beautiful things and the useful things about the data that comes out of the statutory schemes that require the collection and reporting of data is that the data can then be scrutinized. And it has been closely scrutinized. And we now have answers to many of the questions, such as the one you speculate about, which is, do we see that coercion is a factor? And the answer is no.
Can you talk about the possibility of pressure when it comes to disabled people?
That's now been very closely examined, and the answer has been no, it hasn't. So while the concern may have been valid before there was an open practice and any evidence with which to assess the risk, we now have the evidence, and the evidence is people with disabilities are not put at risk when aid in dying is available.
Since you were advocating for disabled people, was there something about the research that maybe changed your opinion?
I believe that the same principles that animate the movement for disability rights animate the movement for end-of-life liberty. That what we're talking about in both of those contexts is empowering the individual with information and the ability to make their own informed choice for themselves. And so I have always thought that the disability rights movement and the end-of-life liberty movement shared common principles and beliefs. And part of my task as an executive director of a disability rights group is to bring that forward. And I'm excited to do that, and I hope that what we'll start to see is more recognition across the disability community that in fact this is something that doesn't need to be of concern. There's plenty to concern people with disabilities that are real risks and challenges, but this is not one of them.
So, Kathryn, let's say I got the form and I received the medication. Do I now have to take it?
What we see from the data is somewhere around 30 to 40% each year are comforted to have the medication, they put it in the medicine cabinet, and they don't take it. They go on to die of their underlying disease. And I think that is a reflection of the fact of how strongly human beings cling to life, and that they're comforted to know they have that option, but they don't come to the moment where they feel they have to act on it.
If I call a close relative, my husband, wife, my mother, and ask them to be present, can they be there legally?
The statutes that permit aid in dying all are essentially recognizing that the patient need not be alone. The patient can invite family to be present, the patient can invite the provider to be present, and in some cases, because of the relationship the patient has with the provider, that will be very natural and something that both the patient and the physician want to see happen. In others, it's very private and it's just family at the bedside. But that's one of the really important achievements of taking this out of the dark and making it a legitimate medical choice, is that people don't have to die alone. and they can be surrounded by whoever they want.
I know that a form of aid in dying has been present in Holland, for example, for many years before we followed that course. Is there anything to be learned from the experience of other countries?
It's challenging to extrapolate from other countries to the US because of the differences in the culture and the practice of medicine within the culture. In the Netherlands, which does have the longest experience with physicians assisting patients to die, it's much more common that a doctor has a relationship with a patient over the course of a lifetime, and that's a long relationship where they know each other well. In that context, that culture was comfortable with the idea that the patient could say to the doctor, if I find myself in extremis, I want you to administer a life-ending medication, and I know you'll know when the right moment is. That model is not how medicine is delivered in the United States in this day and age, and so there isn't the support for the idea that the physician would administer medication to precipitate death. The support in this country is for patients to be empowered to self-administer because it increases the certainty that the patient wants that choice.
There seems to be a little bit of mission creep going on in Holland where now maybe people with depression are looking to aid in dying. Is that somewhere that you think the laws will go in this country?
I don't see that happening in the US. In this culture, the support for aid in dying is very much around a patient who's fully mentally competent, who might have sadness about their death. I think everyone can appreciate that there would be a normal sadness, but if there is a mental health condition that impairs decision making, that person would not be eligible.
Can you talk about the federal-state interface when it comes to instituting these statutes?
For the moment, the option of aid in dying is governed by state law. So unless and until, for example, a different lawsuit were to go to the United States Supreme Court, which it could, seeking recognition of federal constitutional protection, for the moment, this is left to the states. And the regulation of the practice of medicine is largely governed by state law.
What and why is the lawsuit that you're joining against the statute, the California law?
I am involved as an attorney in representing a group of patients and physicians in the state of California in an effort to have the California Supreme Court recognize that the choice of a dying patient for a peaceful death is protected by the California state constitution. And that lawsuit, if it is successful, would cast into doubt many of the provisions of the end-of-life options statute because the state does not permit heavy-handed intrusion of government into decision-making by patients if it is a privacy right. Our hope with the litigation is to have the choice recognized as a matter of privacy so that what can be imposed on the exercise of that choice is much more limited than you see in this rather burdensome statute.
Do you see this as a constitutionally protected right?
The arguments that we're advancing include the argument that this is a right protected as a matter of privacy, as a matter of autonomy, a matter of liberty, and is guaranteed by the Equal Protection Act. So we have a number of different constitutional arguments that the court could embrace. And certainly, I believe as a civil libertarian that this is one of the most profoundly personal choices to be made in a lifetime, and it is deserving of protection as a matter of privacy.
Let's say a decade from now, Kathryn, how many states do you think will adopt aid in dying legislation?
Looking forward over the next 10 years, I think we will see continued expansion of end-of-life choice to include aid in dying. I think and I hope that we'll see that in various ways, that some courts will recognize state constitutional rights, that perhaps some states will recognize that there's no prohibition in their law and just start permitting patient access to this through traditional regulation of medical practice, best practices, and we may see additional states adopt statutes. So I think there are a number of different ways where we'll see the trend in favor of more autonomy continue to grow.